Hello, everyone. Welcome to another edition of the Makdisi Street podcast. My name is Sadi Makdisi, and I teach at UCLA, and I'm joined by my brothers Usama, who's at Berkeley.
Hey, it's great to see everyone again.
And Karim, who's at the American University of Beirut.
Hello.
And we're joined by a special guest again this week, Professor Richard Falk, whom I'll introduce in a minute. But I want to just say that one of the aims of this podcast, which obviously we began in the middle of the war on Gaza, is to kind of give some of the context for what's been happening in Gaza over the past several months of catastrophic violence inflicted on the people of Gaza, and of course on the West Bank as well, and Lebanon by the state of Israel. Some of the guests we've already had on the podcast in the past have helped us situate this, what's happening now, historically and legally and culturally and otherwise. Our first interview was with Francesca Albanese, who's actually Professor Falk's successor as the UN Special Rapporteur on the human rights situation in the occupied Palestinian territories. We've also talked to the historian Ilan Pape, the physician Ghassan Abu Sitta, the liberation theologian Mitri Rahib, and last week we talked to the Palestinian lawyer Diana Bhutto. So all of this is an attempt to fill in the various cultural, legal, historical contexts. This week, as I'm sure our listeners know, the International Court of Justice in The Hague will be having some sessions on the case brought by South Africa against Israel for the crime of genocide. So we're going to be focusing our discussion on the genocide charge, on the case brought to the International Court of Justice, on the very question of what is genocide, and obviously on the legal and political repercussions of the case being brought this week. Our guest this week, Richard Falk, really needs no introduction, I'm sure, to our listeners, but just for the record, Richard Falk is the Albert Milbank Professor of International Law Emeritus at Princeton, and he's been affiliated with the University of California at Santa Barbara in different capacities since 2001, most recently at the Orphalia Center for Global and International Studies at UCSB. Professor Falk has also served in a number of capacities for the UN, most prominently as the UN Human Rights Council's Special Rapporteur on the human rights situation in the occupied territories, which he served, the role that he served in from 2008 to 2014. He's also the editor of a staggering number of articles and books. I'll just mention a couple of them just for context. The first book of his that I read is The Great Terror War, which came out in 2003. He's also written or co-authored books on the coverage of the Middle East and war in general from the New York Times, a book called The Costs of War, International Law, the UN and World Order After Iraq, 2008, Achieving Human Rights, 2009, and many, many other works besides. And of course, Richard has been following and writing about the situation in Gaza since October 7th, including in a number of pieces on his excellent blog, Citizen Pilgrimage: Global Justice in the 21st Century, which I'd encourage all of our listeners to take a look at. So we want to begin this conversation, Richard, if we could, by talking about the question of genocide. And I come at this obviously from a literary angle, and I'm always interested. Of course, there's grave, legal meanings to all these terms too. But I've always been struck at in conversations around what's happening in Gaza, all kinds of legal terms come up, like, for example, war crimes or crimes against humanity, and now obviously most recently genocide. Although the term genocide has been used, including by yourself, by the way, as early as October, people were already talking about what's happening in Gaza, Israel's war in Gaza as a genocidal act. So maybe one way to begin is kind of a general question about when we think about terms like that, from a lay perspective at least, genocide, war crimes, crimes against humanity, how do all these crimes relate to one another? is genocide worse than crimes against humanity? Is it a kind of crime against humanity? And again, you'll have to pardon my legal ignorance, but I'm sure I speak for many of our listeners as well, that I don't know how to separate, how to distinguish these terms from one another and what their significance is in terms of international law. So if you could just start there with what is genocide and how can we differentiate genocide from the other crimes that Israel has also been accused of in its war on Gaza?
Well, it's good to be with you, all three of you, and you pose rather complicated issues that are really the subject of introductions to international law in an academic context, and don't have altogether comforting answers. Lawyers have this characteristic of being able to take contradictory positions. Law is inherently ambiguous, allowing arguments by opposed interpretations to seem plausible enough to require adjudication or judgment by those with the authority, and they don't agree quite often. I would expect, for instance, this South African initiative at the International Court of Justice not to yield a unanimous opinion on the preliminary question that's been posed for it and will be the subject of these hearings later this week. Now, when you go to the question of how genocide relates to these other kinds of crimes, genocide comes into the public arena in a prominent way at the end of World War II. And it comes as a way of describing the originality of the Holocaust. That was the original motivation of Raphael Lemkin, who was a Polish Jew and responsible really for bringing this vocabulary into widespread usage. But it should be remembered that at the Nuremberg trials of surviving military and political Nazi leaders, genocide was not included in the indictment because it was viewed as something, as a legal norm established after the events. And therefore, the crimes prosecuted at Nuremberg were crimes against the peace, crimes against humanity, and war crimes, routine war crimes. And this has always puzzled people because, again, there's a fundamental ambiguity because even the Genocide Convention, which is the treaty that is relied upon for a definition of genocide and how it should be implemented in legal practice, even that in its preamble acts as though it's codifying existing law rather than creating it. So in one sense, Nuremberg was wrong to treat it as customary because it was wrong to treat it as retroactive because the norms existed in customary international law supposedly, by one line of interpretation. But I think on this issue, for various reasons, the lawyers responsible for prosecuting the Nazi leaders who survived thought it best to leave the crime of crimes, which was the Holocaust, and which is often used to differentiate genocide from these other categories of criminality. It ended in a sense. Nuremberg had two defects that are sort of relevant to our discussion. One is it left out of the scope of its undertaking what most people in the world thought was the worst crime, the genocidal killing of millions of not only Jews, but principally Jews, also gypsies and people thought to have defects from the sense of racial purity, of which homosexuality was one, and being extreme left was another. So that was one. And the other thing that was left out, not of Nuremberg, but of the Tokyo parallel tribunals, was the crimes of the victors. And the biggest crime, probably in the war itself, was the atomic bombing of Hiroshima and Nagasaki. And we'd have a different world if that hadn't happened, or it had been done by the losers in the war. So there was this combination of victor's justice, which disallowed the tribunal to inquire into the crimes of the victors. And that is a characteristic of international law and the UN that's often overlooked. It's designed to be weak. See, it's designed, the UN Charter conferred on the most dangerous countries in the world in terms of power this right of veto, which is in effect telling the powerful they don't have to obey international law if it clashes with their strategic interests. And this correlates with victor's justice, where you leave out of account the crimes of the victors. And I've categorized these features of international legal order as according primacy to geopolitics. And therefore, law is deliberately subordinated or marginalized in those situations where strategic priorities are pronounced upon. So maybe Richard, I stop there. I'll give my whole introductory course lecture.
No, it's fantastic, Richard. Just a quick question, if I could follow up on that point, just for the viewers and listeners. When you say that in World War II, and this is relevant to our discussion today, when you say victor's justice and they refused after World War II to prosecute or to consider the dropping of nuclear bombs and the annihilation of civilians by the Allies, is that they just refused, or was there a legal argument they used to not deal with it?
The authority to prosecute was established by the so-called London Agreement, which ironically was agreed upon by the leaders of Soviet Union, UK, and US on, I think it was August, or something like August 7th of 1945, which comes just between the two atomic bombs that were dropped on Hiroshima and Nagasaki. So there was a total insensitivity to the crimes, the criminality of the victors. And they gave no thought to anything other than their strategic conceptions of how to prevail in the war, and didn't show any sensitivity to legal constraints. And in a way, it is a kind of historical and conceptual precedent for what is happening in Gaza and indirectly in the West Bank for these past 3+ months. So it's significant to look at how the international order was constructed after 1945 to understand that from one perspective, a strictly legalistic perspective, what the shielding of Israel from accountability or from constraining itself within the limits of law by the US and other global West countries is part of the arrangement. It has they're not doing anything legally wrong. They're doing things that are terribly, I would argue, morally decadent and politically short-sighted. And it's important in thinking about genocide that one distinguishes its moral character, which is the indiscriminate killing of a distinct group in whole or part, from its political implications of whether this is a viable kind of way of a dominant group dealing with a minority, and from a legal point of view, which requires this kind of intervention by legal institutions. They don't have to be international institutions. There is such a thing as universal jurisdiction that allows national courts to pass judgment on international crimes. And the Center for Constitutional Rights in the US has initiated a lawsuit against Biden and some of his associates on this sort of theorizing based on a universal status for the crime of genocide, which can be invoked within national legal systems.
Richard, can I, so just to backtrack on one thing and to get sort of a bit concrete about the case that we're talking about today. So from the Genocide Convention itself, according to the Genocide Convention, it defines genocide as, quote, any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group, right? And that's the Genocide Convention definition. And in the South Africa case, which is now coming to the International Court of Justice, in their case, they say, and I'm quoting from the report, that they describing Israel's actions in Gaza as, quote, genocidal in character because they are intended to bring about the destruction of a substantial part of the Palestinian national, racial, and ethnical group. The acts in question include killing Palestinians in Gaza, causing them serious bodily and mental harm, and inflicting on them conditions of life calculated to bring about their physical destruction. This is the kind of the South African application that they want to bring to this International Court of Justice. So a couple of questions, if you could just clarify a couple of things. Firstly, what is this connection between this Genocide Convention and having South Africa, for example, bring this case to the International Court of Justice? So what is this World Court, this International Court of Justice? And is it taking from the Genocide Convention these definitions in order to then assess, yes, the Israelis are committing genocide according to the Genocide Convention, or can they kind of define their own terms? Can they come up with a different understanding of what genocide is depending on the case itself?
Those are very appropriate questions, Karim, and there's, again, no fully satisfying answer to the questions, as there is this zone of ambiguity that applies, and the court, for instance, or any of its 15 judges plus 2 ad hoc judges representing the two parties to this case, they can answer those questions in their own way. There's no authority beyond them. So but I think there's no doubt that the South African initiative is validated by Article 3, I believe, of the Genocide Convention, which gives any party to the convention the authority to initiate legal action if there's a dispute as to whether genocide is occurring or not. And both Israel and South Africa are parties to the Genocide Convention. And this is a case before the International Court of Justice, which has 2 parallel types of authority. It can handle a dispute as to a legal dispute in which is accorded in which it's accorded authority to decide by the parties or by the underlying legal document, as in this case. If there wasn't this provision in the Genocide Convention, I have strong doubts that Israel would ever consent voluntarily or at the moment to submit this allegation to the International Court of Justice. And they've already used this very hyperbolic language to characterize the South African initiative as a blood libel against the Jewish people and as baseless. So from their point of view, the whole thing should be dismissible. It has no legal foundation. And apparently they've hired a UK law expert who's written books on genocide, Malcolm Shaw, who's fairly conservative international law person, to represent them in this trial or or in this legal action. And one should understand also that this is a preliminary. This is not the substantive finding of genocide. This is a request by the South Africans, because of the emergency conditions, to issue what they call in technical language provisional measures, by which they can decree that Israel terminates those actions which have the appearance of genocide. They still are free legally to find that this doesn't, in the end, that this doesn't qualify as genocide, because the parties will not have made their presentations on the merits. It's just on whether this authority exists and whether it's plausible to, at this point, issue, whether there's enough evidence in this 94 or 84-page application to justify provisional measures.
So, Richard, just a quick question. Why is it South Africa that had to present this? Why wouldn't the Palestinians have been able to present this case? So why did the world have to wait for South Africa? Is it just because South Africa is party to the convention? Why not the Palestinians? Are they not party? Are they not allowed to do this themselves? And what about the fact that how many states need to indicate support for this in the coming days and weeks? Because so far it's Bolivia, I think, Malaysia, Turkey, I think Jordan, who have expressed support. And does it have to be, I mean, how many states need to sign on? Can you give us some sense about that?
Actually, no other state would have had to endure. The South African initiative stands on its own merits, and it doesn't require this kind. It's more of a political show of the plausibility, in a way, of the South African initiative. Why South Africa? South Africa has always had a sense that what is happening to the Palestinian people was what it experienced during the apartheid period. And if you recall, Nelson Mandela and Archbishop Tutu made very strong statements when they were alive about our freedom depending on Palestinian realization of their fundamental rights. And there were statements made by another of my predecessor, in this case, John Dugard, who's a South African jurist who has, along, I think, with Archbishop Tutu, said that what we experienced in South Africa as apartheid is even worse in what Israel has been doing in occupied Palestine and in relation to the Palestinians. And it's important that you raise the question, because people tend to think that the criminality of Israel's behavior started just with October 7th. But the broader context shows that in the last 5 years, a whole series of international actors issued reports that characterized the Israeli government as an apartheid regime, which is a serious crime. It's subject to the enforcement in the International Criminal Court, and there is a parallel case to this case that's been initiated by, I believe, Algeria and Chile that is raising these questions. Whether Palestine Authority would have the status to represent the Palestinian allegation within the International Court of Justice is uncertain, and to some degree, though Palestine is a party to the Genocide Convention, and technically would seem to have the same legal rights to act upon it as any other party, and whether its collaborative nature led it to feel unable politically to take such an initiative. I haven't seen the question intelligently discussed, and so it's really part of the black box that has kept the motives of the Palestinian Authority rather unknown and unknowable.
Richard, so just to clarify this again, there seems to be three different cases going on now. One is the South African case that we're talking about, and I'm going to ask you a few more questions about this, but that's one case. The second case is what you just mentioned, the International Criminal Court, the ICC, where the Algerians and I think the Colombians have also kind of co-sponsored trying to get the ICC to take up Israeli war crimes within the International Criminal Court. That's as a parallel, separate but parallel track. And then before that, there's also a third case that the ICJ, the International Court of Justice, is also supposed to be looking at on the question of the legal consequences arising from Israel's prolonged occupation of Palestinian territories. And that's brought through the UN General Assembly. So these are at least three cases that I know about. Perhaps there are more, but these are all very recent cases and contemporary cases. And
the fourth case is the American case. You know, the Center for Constitutional Rights
right.
Effort to prosecute Biden for complicity. And we shouldn't forget the complicity crimes are very important, in my view, in evaluating this whole pattern of litigation. It's arguably more important politically for a favorable judgment at the ICJ on behalf of South Africa. It's more politically important in influencing the U.S. than it is Israel.
So in the case of the International Court of Justice, you have 15 judges, and these judges are presumably, I mean, in theory, they're independent judges, right? They don't represent the countries. They're appointed through the General Assembly, I think, right? I think there's a vote or something within the General Assembly to appoint a World Court judge, but these are meant to be independent judges. And then when there's a specific case, each of the parties gets to add on, what you call this ad hoc judge. So in total, there ends up being 17 judges. And ultimately, in this case of the South African case, for example, is it just a simply majority vote? I mean, X number of vote end up saying this, the others say that, and it's majority. How does that work? And in the case of the provisional, the injunction, if there's a vote that says, okay, yes, provisionally, we're calling, what would it be? It would be, we're provisionally saying there's potential genocide here, so therefore you need to stop, while we are going through the full kind of caseload, and maybe, whatever, 1, 2, 3 years down the line, we may determine, or we may not determine that it's actually genocide, but in the meantime, you need to stop whatever you're doing. Is that the idea?
That's essential. Again, it's not been very clearly defined, and the court is not bound by the treatment of these issues in the past. See, it's not bound by precedent. It may be influenced by precedent, but it's free to ignore or even repudiate prior judgments. There was this effort to establish provisional measures in the context of what was happening in Bosnia in the midst of the war there. And provisional measures were issued in that situation, and to some degree, it's again factually disputed, implemented. The issue here is whether a majority of the judges are willing to go on record as saying South Africa has demonstrated enough of a reason to suspect that the allegations of genocide are legally authoritative, so that we should interfere through issuing orders to desist from the acts that are inflicting death and destruction in Gaza. That's really the issue that they are faced with. And
Richard, sorry to interrupt. Is it simply a simple majority within the judges to make that kind of decision?
yes, that's my understanding.
Of the 17 judges, there'd be a
yes.
majority. Okay. And this, so the urgency, they're meant to meet now this coming Thursday. And so the urgency is to try to put basically this provisional, to presumably if the majority of judges agree or find that there's enough of a case that the South Africans have brought in, then they might pass and hopefully will pass this kind of provisional agreement to say the Israelis must stop. If that's the case, if they do that, of course, who knows, but on the assumption that they do that, what are the legal or political implications if the Israelis simply say, you know what, I ignore this, I don't recognize it, I don't want this, and just continue?
Of course, we don't know. There hasn't been enough experience with that kind of defiance of a judgment. There certainly have been instances where the judgment is not implemented and requires Security Council action if the UN is to implement it. And there is this implementation crisis affecting international law, that the norms are there. In other words, the rules are there, but the political will to implement them is absent in very many cases. And that's part of what I was trying to express by reference to the primacy of geopolitics. International law is as enforceable as the geopolitical consensus allows, but it's
Richard,
also unenforceable to the extent that it opposes. Sorry, yes.
No, Richard, so a few things. Those of us who are looking to the ICJ, all these incredible crimes the Israelis have been committing these unspeakable crimes, right? They've killed, injured, or made to disappear under the rubble 31,000 people so far in Gaza. 5% of more or less of the population. They've cut off foods, food, medicine, water, fuel, and so forth. They've demolished, I can't remember, 70 or 80% of the housing and so on. So we're all, at least again, naively, some of us have been looking to the International Court of Justice to say, oh, thank God, now surely the ICJ is going to rule and this will stop and so forth. But part of what you're saying here is, and obviously, how could we argue with you, is that that would be sort of a naive proposition in the sense that at the end of the day, the international legal system has these geopolitical constraints and American veto power and so forth. It's not a bug, it's a feature of the system, in other words, right? So I guess we're going down a path where we should all sort of take a deep breath and not minimize our expectations, but be realistic in our expectations as to what could happen this week, right? That even if the ICJ does say, yeah, this is obviously a case of genocide, we call upon the Israelis to stop what they're doing. The Israelis, I would assume, since they violated every other rule in the book, they might as well I'm sure they'll just say, well, we're going to go on doing this and so forth, and nothing will make a difference. In other words, so how much hope should we have here, or is it naive to have hope in a case like this?
Richard, sorry, let me just to add to what Sally is saying there. I think it's important, and I think, Richard, you were sort of alluding to this earlier. It's likely that if the ICJ does, let's again assume they do come up with a majority that says, provisionally something's going on and you need to stop. The Israelis will presumably say, no, this is not the case, etc. What is it that, are the implications to the third parties? So in this case, the United States, or some of the European countries, or some of the other countries that are aiding and abetting this Israeli kind of war. Are the implications to them legally, politically significant that will make them hesitate more? Or is that also, of course, subject to geopolitics, etc.? But the United States, the Europeans in particular, presumably have more, they care more about their image, the more about, where they stand in world order than the Israelis do in many cases. So you've written so much about questions of geopolitics, but you've also, you haven't mentioned, but something very important that you've talked about for so many years, which is legitimacy wars, which is the idea that on that level, while geopolitics tends to win on the kind of in the real world, so to speak, the legitimacy wars, the idea of courts ruling in favor of kind of a just cause, or in this case, in favor of at least trying to say there is a genocide, or there's genocidal intent, or something's going on, it does have some kind of impact, or it does have some kind of influence, let's say, on, if not Israel, but on all the other actors that are supporting, the Europeans and Americans and others that are supporting the Israelis.
Well, what you're saying, Karim, relates to what Sari was saying too, which is how can we assess the potential effectiveness of a favorable ICJ response to the South African initiative? And the realism comes from any expectation that Israel will comply, because it will feel the need to show it's a good international citizen and upholds a decision of this serious character. That's where it would be, in my view, given the record and given what they've already said about this initiative, very naive to expect that. So also would be naive, given the US record at any rate, to expect any meaningful pressure. US has also cast doubt on the validity of calling what's happening in Gaza genocide. The State Department issued a formal statement indicating its lack of support for the initiative. So what and Israel has sort of, if you remember, the International Court of Justice was involved with the U.S. effort to oppose the Sandinistas in Nicaragua back in, I guess it was the
1986, I think, wasn't it?
86, yes, and they issued a decision, but before they issued the decision, the U.S. withdrew from the case. You know, it anticipated the outcome, and it renounced its acceptance of the court's authority and just withdrew. Now, I would imagine Israel will play those lawfare games in the event that they sense an unfavorable decision, which I think is very likely. Having said all this, it's still an extremely important moment in the struggle against this kind of horrible Israeli behavior. And Karim rightly referred to what I've called in the past the legitimacy aspects of international issues of this sort. And by that I mean that even if the involved governments don't comply, such a decision will have a mobilizing effect in civil society. And whether that mobilizing effect leads to a much more robust boycott of Israel or other actions taken by the Global South or the Organization of Islamic Cooperation, which has also supported the South African initiative, it is politically consequential, even if it's in a technically legal sense, it looks like what the court says or what the UN tries to do, it doesn't seem to matter. See, and the U.S. has paid a high political and reputational price for casting a veto in the Security Council. It's fully within its legal rights to do that. But the shaping of behavior interacts with political reality and with moral justifications. And the importance of this case, in my view, is on these levels as influencing civil society, and particularly the Global South, and probably the European countries, for the reason that Karim suggested, that a greater sensitivity anyway. I mean, the European countries will face a tension between taking this kind of outcome more seriously and their so-called priority allegiance to NATO membership and U.S. Diplomatic leadership. So it's uncertain how they will respond. And it's connected even to the Ukraine war and how they think that will be affected by what they do or don't do in relation to Gaza. So there's, again, no clear-cut answer to these questions. But one can say with a certain confidence that these provisional measures, if they are endorsed by a majority of the court, are unlikely to be implemented by the governments that are the targets of these orders. And at the same time, it will have significant political and moral weight in influencing international public opinion. And one should remember that all of the anti-colonial wars were won by the side with the weaker military capabilities. My underlying argument has been that at this stage of history, the legitimacy issues do, in the end, prevail. But there may be a great deal of suffering and devastation that occurs in the interim. Vietnam is in some ways a paradigm case where the US won every battle and yet lost the war. Now, how does one explain that? And a total military superiority.
And Algeria, of course, as well.
And Algeria is another example. And South Africa, in its own way, is an example, not quite of a war, but of a ongoing conflict. And global solidarity was very important in the Vietnam and South African cases. It was not just what was happening internal to these countries. And the Israelis understand this. That's part of why they've been so unscrupulous in relying on the weaponization of anti-Semitism, for instance. They take very seriously these global solidarity initiatives that come not from governments or political institutions, but from people organized as citizens engaged in trying to influence behavior.
So, Richard, can I just jump in here and ask you on this point, since you've made it very clear, it seems like crystal clear that what you've been saying and what Sadi and Karim have also been asking you about is that the international order, the legal order, as it has been set up, privileges the powerful. And you're saying we shouldn't be naive to expect, and our listeners and viewers shouldn't be naive to expect anything radical in terms of the geopolitical outcomes in the immediate sense, given the fact that this is the ICJ, it's part of the UN. The UN itself was set up to privilege the powerful after World War II. So then what do you say to people who, for example, in the so-called axis of resistance in the Middle East, those who are fighting against the Israelis on the ground, who say consistently international law is a waste of time. International law is simply something that the West has created that will never be implemented, given what you've said, will never be implemented against the powerful. And therefore, we have to rely on ourselves only and forget international law and forget appealing to international law. So I'm wondering, how do you reconcile these two things? Do you think it's short-sighted on their part, or is that just an inevitable point of dispute, or how can you educate us on that point?
Well, it's a partially justified a reaction, because if you're looking to the formal institutions of either governments, powerful governments, or international institutions, unless they are agreed about something, there will be no response forthcoming. For instance, when they agree, as they did in relation to Libya in 2011, or in the first so-called Iraq War after the invasion of Kuwait, annexation and when they agree, they can almost be too effective. In other words, when geopolitics reinforces a legal claim, it prevails. It has enormous impact. But when it contradicts, as here most dramatically, then a partial dismissal of the relevance of law is fully understandable, but it should be understood as partial because civil society is also a player. See, and that's what the uncritical total dismissal and skepticism lead to. International law does matter, but it doesn't matter in a simple and familiar way. And it doesn't matter the way domestic law matters. And if you understand those qualifications, then it can be extremely important. And I think one can attach quite a bit of importance to this case because it's in a context where there's a lot of outrage against Israel that will be validated if these orders are made and if Israel persists, as I think it will, in trying to carry out its ethnic cleansing scenario and forced evacuation from Gaza itself and the West Bank. I think that there will be a reaction. Israel is very dangerous in this period because it's cornered. It can neither win nor lose. See, it can't win because it has undertaken something that it can't carry through to completion. And it can't lose because it staked so much of its reputation and international standing and domestic legitimacy within Israel on winning. So it's trapped, and the only thing it can do is this option of a wider war, so people somehow shift their attention to Iran rather than Gaza. See that, and that's a very frightening scenario for the coming months, that this will expand under these conditions.
That's something, Richard, that we'll come back to in a second. But just to tie up this last thread that we've been talking about for the past few minutes, let me recap it this way. It seems like part of what you're saying is, if the ICJ rules appropriately and says this, what's happening looks like genocide, and therefore we call upon, like a kind of injunction, we call upon the Israelis to cease immediately their actions. And of course, if the Israelis and their American patrons ignore it, which seems like that's what they'll do because that's what they've done so far, and that's generally their modus operandi. In other words, even if legally speaking, an ICJ ruling doesn't have any enforceability or doesn't have any kind of bite, legally speaking, it will add to the continuing accumulation of other forms of what you call the legitimacy struggle, right? So it'll add to the reports about Israeli apartheid, for example. It'll add to the 2004 advisory opinion about the wall in the West Bank. It'll add to this sense of the Israeli state as lacking legitimacy or even shorn of legitimacy altogether in the so-called court of public opinion, right? So in other words, even if governments don't act, as you're saying, civil society can still act, and this will give greater impetus to, I mean, I would anticipate, even with or without the ICJ ruling, I would anticipate, as if we've already seen here in the US, for example, a greater impetus for civil society to act in terms of protest, boycotts, divestment, sanctions, and so forth. And the ICJ ruling on top of the apartheid reports in the past 2 years will add to that, will give further weight to that civil society struggle, which, as I think you were saying also, as you were suggesting, I think, in the case of South Africa, for instance, what brought about the end of the South African apartheid regime wasn't government intervention, the US and the UK and so on. It was rather a civil society boycott. That's what helped bring about the end of apartheid in South Africa. And so perhaps we can expect something similar in this instance. So this is further ammunition, so to speak, for the moral, as opposed to, strictly speaking, the legal cause. Does that sound about right?
Yes, I'd add political to moral. I mean, it's not just a matter of disapproval, or it's also political action that follows from moral outrage and a frustration with the failure to abide by or comply with international legal rulings. People really wanted the ceasefire resolution, even though, again, if we had been talking about that, I would have anticipated its repudiation by the states supporting Israel and Israel itself. But it would still have been very important as a way of demonstrating Israel's defiance of what one might call an international consensus on appropriate behavior.
Richard, and I just want to follow this. I think it's very important. The idea, for example, it seems to be that basically, if the International Court of Justice rules comes up with an injunction, says you need to stop, the Israelis say no. Which is presumably what will happen. The key part of this is it adds this, as you're saying, this kind of legitimacy to global civil society, global solidarity movements, etc., to be able to say, look, Israel has become even more illegitimate, and this is being confirmed through these, quasi or in fact independent bodies and institutions. But there's another side to that. Beyond that, I think, which should be interesting to hear from you as a lawyer. You mentioned it very early on, briefly, on the question of the universal jurisdiction. And if the court comes out and says, yes, there is at least reason to believe that there is genocide here or genocidal intent, and I know I've been reading that there's various civil society groups, lawyer groups, constitutional rights type groups, in Europe, I think in particular, I know in Holland and in England and other places where they're trying to say, okay, if they can identify dual citizens, Israeli dual citizens, for example, a Dutch or British or French or something like this, and then try to take to the national courts there. The idea of having a ruling from the ICJ or the International Criminal Court, if that ever materializes, and say, look, it's not just us. There are these other bodies that are also saying and agreeing that there is a proper case for genocide here. Here are these individual people that are also clearly part of this. Can they not also be taken to national jurisdiction courts? I don't think in the US they can do this, right? But at least in some European countries.
I didn't get the last part of what you were saying. You mean you want a court to proceed as a criminal court, or?
Yeah. To be able to use the logic to prosecute in national court settings in Europe, in European countries.
In other words, I think what Karim is saying is, wouldn't an ICJ injunction also lend support to the possibility of legal cases in national courts, right? That's what you're saying, right, Karim?
Yes,
Yeah.
it all depends on the national law, and there's not one national. Different countries have different approaches to this issue, even if they have some provision for universal jurisdiction, they may frame it in different ways, and so one would have to look from state to state. But there are definite possibilities, and it would all be part of a process of trying to mobilize civil society to take action. Go beyond rhetoric, go beyond condemnations even, but to do things that exert pressure. And that's what seems to have happened in relation to South African apartheid, and in where civil society has been effective is where it can mobilize enough support to have tangible political impacts. And that happened in the anti-war movement during the last stages of the Vietnam War here in the United States. The Vietnam hawks still say the Vietnam War was lost in American living rooms. And that by that they mean the effect of this prolonged war, which couldn't be explained by national interests in a persuasive way, turned the people against the war.
Richard, could I just take you back to something you said earlier and ask you for your comments on when the Israelis responded to the South African case or brief or application, the 84-page application, and they called it a blood libel. And they also consistently, and their supporters in the West consistently insist that Israel is being singled out. So I'm wondering, is that true? Is Israel being singled out in your estimation? And then what about their arguments when they say, but Hezbollah and Hamas are committing war crimes and they started this? How, from an international legal perspective, does one sort of deal with these points? A, the question of whether they're being singled out. B, the question that the other side, so to speak, has committed war crimes, and therefore what Israel is doing is self-defense.
No, those are good, important issues, Osama, and they're not new. Israel has long argued that that others are doing far worse things, and that at the UN it shows its anti-Semitic bias by focusing so much energy on the occupation of Palestinian territories since 1967. The most direct response to that is that the UN, ever since the British Mandate, was given a special responsibility for a special responsibility for achieving some kind of sustainable peace in Palestine. And it attempted to do this through the original partition plan of 1947 that was negotiated within the UN itself without really consulting the people, without consulting a Arab majority indigenous population. So it violated the notions of self-determination and so on. But overall, the UN has a special responsibility that it doesn't have toward any other entity in the world. And it's a responsibility that it's failed to discharge successfully. It's been not entirely due to its own fault, but due to the behavior of some of its leading members. And therefore, the notion that, especially since 1967, when it became Palestine became occupied territories, the UN had a special responsibility for seeing that the civilian population of occupied Palestine was being protected, which is the overriding commitment of international humanitarian law as it's embodied in the Fourth Geneva Convention on Belligerent Occupation and in the first protocol, which elaborates on that Geneva Convention. And it also imposes on the occupying power an unconditional obligation to provide adequate food and medical facilities to the occupied people. And so the Israeli orders at the beginning of this operation by the defense minister, Gallant, were completely in violation of this UN-type framework. And the whole idea of claiming self-defense against hostile actions that emanate from territory that is being administered in an occupied from a perspective of international occupation makes no sense, because you can't, you're defending yourself against yourself in that sense, because Israel has this political responsibility, and they've failed to uphold the Security Council unanimous decision back in '67 of arranging prompt withdrawal. It's now over 50 years. So that argument is a really very thin argument without any substance. And of course, given the severity of what's been happening in the last 3 months, it completely sidelines any serious consideration of that kind of reasoning. Whether the others have committed crimes along the way depends on a careful analysis of the tactics that they've used. The deliberate killing of civilians is a crime, whatever the is a war crime, whatever the motivations might be, and however justifiable the resistance might be. And also hostage taking is prohibited in the Geneva Conventions. And so those are clearly capable of being treated as war crimes, though they are so insignificant in the larger context of what has happened since October 7th, that it to stress them or to equate them becomes an exercise in falsification and deflecting attention from where it belongs to be.
Richard, we need to wrap up, so I just want to, maybe ask something which I think a lot of us, I mean, I assume a lot of the listeners and viewers, this notion of, you look at whether one has read the South African application or not, these kind of 80 pages. The most prominent thing that has come out of this is this collection of, in the discussion genocide, of course, they say the most important thing is trying to show intent. How does one prove intent? That's always the most difficult thing. And that this case, it seems to be unique in how the leaders from the top downwards have been basically like standing at rooftops and screaming that we want to commit genocide, or we want to commit war crimes, or we want to, get rid of people and do ethnic cleansing and make Gaza uninhabitable. It just seems to just lay people like ourselves so incredibly self-incriminating, to be so obvious that it doesn't require 10 years worth of courts and I don't know what to kind of go through this. Of course they will, but just it seems so absurd that somehow the Israelis can somehow win this case or not lose this case. So my question is, how do what case do the Israelis have? How can the Israelis defend themselves, having made their intent so clear through all of these statements that the South African case has so neatly and so concisely, so incredibly detailed, kind of put all this case? And with that, how do you see this case kind of going? What would you expect the coming weeks and months be? And a country that is facing different parallel cases, accusations of apartheid, which is going forth, accusations within the ICC, accusations about occupation and the kind of consequences of occupation, and now accusations of genocide. All of these things coming together. How do you see this kind of going forward?
Well, that's a very overwhelming question in a way, because there's a lot of uncertainty surrounding what happens and how the principal actors will try to manipulate what happens to correspond with their strategic goals. And so this will be a kind of surrealistic legal drama in a way, that how a favorable ICJ set of provisional measures is addressed. But as I've said all along, there can be arguments put forward that may not be persuasive to the four of us, but have enough legal plausibility that they can be advanced. And of course, the self-defense argument is made in the context of anti-terrorism, and terrorism is the characterization of Hamas and the tunnels that Hamas has, tunnel network that it has constructed in Gaza, can be interpreted by those that want to see the issues through a Zionist optic as creating a situation of no alternative for Israeli security and sovereignty. And supposedly 80% of Israelis really believe that what Israel has done in response is justifiable, and don't see it, they see it as a form of self-defense in a situation of counterterrorism. And they characterized their adversary as terrorist, and they take comfort from the way the US handled post 9/11 terrorists. There are, in other words, that the notion that their constraints apply is really suspended, or and whether that argument has any followers among the judges of the court will be of interest and will affect the degree to which the court does have a major impact outside the global south. See, it could have if the decision is close, let's say 10-7 or something of that sort, then there would be a strong case for saying this isn't an authoritative decision, and the global West will not alter its policies in response to such such an outcome that doesn't command total support from the court. I mean, and that's part of this initial issue of the ambiguity of law. I mean, if law was so clear, there shouldn't be any dissent. There should be unanimity. Even the Israeli appointed judge, if he's true to his pledge of independence, should find the case compelling for the issuance of provisional measures. That's an outcome too good to believe possible.
Richard, can I just, sorry, last interruption. How, in your experience, how independent are these judges? The other, not the Israeli one, but the others. How and what form of pressure that, for example, the Americans and others, the Germans, Europeans, that will put on these judges? Are they actually independent? I mean, can we look at them and say, these people have conscience, they've got their things, they will vote according to their, what they believe, as opposed to this kind of political pressure they're under? Just in your experience.
Some are and some aren't. That's the real answer. Some are really pretty low-grade political appointees who are very subject to playing the bureaucratic game and would be responsive, would almost seek to be told what to do. And others conceive of themselves as jurists who are staking their professional reputation on upholding the mandate to judge impartially and independently.
Richard, it's not exactly filling us with hope, this assessment, but I guess the hope, if we can derive hope, I suppose it's in the sense that the world was looking at this judgment, and citizens of goodwill around the world, as much as states and governments and official parties and so forth, will also be looking at what happens in The Hague on Thursday and Friday of this week, and then whenever the case goes into the future. So we can hope in that sense that ordinary citizens will realize when they read the South African case, which to me is very extraordinarily compelling, and they see the proceedings and so forth. Hopefully, I mean, what we can hope for is that people will make up their own minds, and then will commit to the continuing application of civil pressure on the Israelis to eventually heed international law on this as on the question of apartheid and many other violations of international law that it's engaged in. We should wrap here and just thank you again for this powerful and helpful kind of assessment of the situation, and above all the distinction between the legal, moral, and political possible outcomes of this case. And in fact, obviously it's a very powerful way for us all to think through the question of international law, the legitimacy of international law, and so forth. That we have to remember it operates at these different wavelengths and speeds. It's not only about how it's implemented by governments, but also how it's read by ordinary citizens of goodwill around the world, which can have meaningful, as we saw in the case of South Africa, can have meaningful political impact as well. So thank you very much, Richard. Yeah.
But I say just one final thing.
Yeah, of course.
It's not very likely, but one kind of hope would be that Israel would itself depart from its usual pattern of defiance and see this as a way out of a situation where it's increasingly cornered between not winning and not losing. See, I think they're facing that dilemma, and it's just conceivable that these provisional measures would give them a way out of saying, we don't agree with what's being said, but we're sensitive to the rulings of others, or some kind of rationalization. I don't think it'll happen, but it's possible. And the other small point is that I think if they do defy a order from the court, that it will not only lead to the continuation of campaigns like BDS, it will lead to their escalation, and maybe dramatic escalation, and to private initiatives. I've been receiving messages about not buying certain things with barcodes that identify them as having been made in Israel. And I think there will be a lot of activation following a defiance of the court. And therefore, it is a very important moment in this long ongoing struggle. Thank you very much for having me. I enjoyed being with you, and your questions were challenging and probing.
Thank you, Richard.
Thanks. Thank you, Richard.
Thank you, Richard. Thank you so much. So that was a fascinating discussion, guys, with Richard Falk. Obviously, like a wealth of experience, a wealth of optimism and realism, right? And I guess my question is, it always comes back to this issue that we're always confronted with, which is that the system itself is built and designed in such a way, the legal international order. And Karim, of course, you've talked about this more than any of us, is built and designed in such a way that sort of privileges the powerful. And he started off with that whole discussion of World War II and victor's justice. And we go all the way till today. And then what I'm left with always is, what is the point of always going back to the same structure that is itself a reflection of power and of injustice and of hierarchy? What's the point of always going back? I mean, this is something that always sort of, it's a question, of course, that academics talk about a lot. But Karim, maybe you could just, what do you think?
There's no way to answer that. I just finished teaching a graduate seminar on the United Nations and international politics, where we read, of course, a lot of Richard Falk. And in the end, you always end up with it's very challenging. You end up saying, at the end of it, there are people looking like, okay, so who cares? I mean, the UN, it's great, etc., but it's kind of useless. They can't implement. They don't do anything. It's geopolitics. It's power, etc., especially in our region. And of course, as Falk is saying, as is obvious, yeah, of course, geopolitics is the most important aspect of this. But the focus, I think, what Richard has focused on for many decades in all of his writings, is what he talked about, this question of legitimacy wars, meaning you're not looking, in this case, for example, that's why I was trying to push him. In this case, the question of the South African case, if it's, if the judges rule on behalf that, yes, the Israelis should stop now, of course we know that the Israelis are not going to stop, and we know that the Americans are going to come out and say, whatever they're going to say, but it will have an impact in terms of the legitimacy that the Israelis operate in. It's legitimacy within which the US can feel like it can support. It adds weight to a lot of the local initiatives, the legal initiatives that I think are taking place in various countries, in particular, I think in Europe. The kind of the weight added towards talking about, will the Saudis continue a kind of normalization tracks when a country has been accused and is very clearly doing it, in a sort of genocidal war. It has this kind of political impacts. It has, I don't want to say moral, but political impacts. It has, I think, institutional impacts. It has impact for global solidarity movements. And, does that mean it will stop the genocide? No, I don't think so. Is that going to mean that suddenly the Israelis will lose everything? No, obviously not. Will the US lose everything? No, obviously not. But does it have some kind of role? I think that's what Richard was making the argument that, yeah, it is important in that respect.
I think it is. I think it's very important. And it's true that those of us who are naively, I'll include myself in this category too, who are naively looking to the international court to say, this is obviously a case of genocide, stop. And then the Israelis go, oh, we're sorry, we didn't mean to do this. And obviously that's not going to happen, right? But as Karim is saying, and as Richard was saying in the discussion, what this does is it's another document added, or another case, if you want, added to the now gigantic pile of documents, the reports on Israeli apartheid, the reports on Israel's routine violations of international law, the use of human shields, the torture that's going on in Israel's dungeons, and all this kind of stuff. It adds to all. It's one more, and it's a big one if it goes through as we hope it does. It's another element in this ongoing conflict. We have to remember that Israel's subjugation of the Palestinian people is not going to stop because governments in the West suddenly feel bad or feel guilty or feel legally compelled to stop. It's going to stop when citizens of goodwill around the world make it stop. That was the case in South Africa too. It's true that yeah, go on. Well, let me just finish. It's true that there was no equivalent of the Zionist lobby that exists today in the case of South Africa. It's true, but as Falk pointed out, at the end of our discussion, there was a very, very strong, geopolitical lobby in the US and the UK supporting South African apartheid because it's met strategic interest against so-called communism in Southern Africa. And there was obviously also massive corporate, interest involved as well. Huge. Yeah, but South Africa is far more important economically than Israel ever has or can be or will be because of the mines, the gold, the diamonds, and the resources and the minerals and all kinds of other things. So there are a lot of things.
Not more important to certain key. In other words, what you're saying, you say that there's a whole lobby system here. It's not just a lobby system; it's an affect. There's an affective relationship with this state that is very difficult to. I don't think you can minimize that, and I don't think we can minimize that in terms of saying this is. In other words, there are so many people who actively, and you can see this in the U.S. more and in Europe, who actively and openly support Israel in a way that I can't remember. Of course, I wasn't old enough to remember South Africa in its pomp racist prime in the 50s and 60s, obviously, or 70s for that matter. I don't remember what kind of support there was for South African apartheid. I think it was more that people took for granted in the West South African apartheid. There wasn't this active support in the way you see. Or am I wrong? Am I just completely sort of?
It's changing, Sama. It's changing. We can't ignore the fact. You're right.
Maybe.
Of course, there has been for years, but it's changing before our very eyes. It's changing.
Yes. The question, Karim. But then the question is it changing fast enough to prevent the actual genocide on the ground, which is everything ultimately comes down to what in Arabic is referred to as Maidan. In other words, what's going on the ground. In action. Yeah, that's the question. Yes. Because in the end, there's an ethnic cleansing campaign. I mean, there is an ethnic cleansing campaign very clearly.
It's a genocide going on, but there's also, on top of that, there's ethnic cleansing that might be taking place even more so again in the West Bank. There's potential. The Israelis are pushing very hard for regional war. They've been provoking Hezbollah here in Lebanon, and they are, I think parts of them are quite desperate to have a regional war in order to distract on not just in Gaza, but what might go on in the West Bank, which is another big issue.
But I don't think it's distraction as such. It's not distraction because the Israelis are doing it openly. It's not. There's no distraction. They're openly ethnically cleansing the Palestinians from Gaza, and they're doing the same on the West Bank. I don't think it's about distraction. I think it's part and parcel of a gambit to push.
We're coming to the end. We're coming to the end of this issue. We have now, just to get to what we're talking about, this question of the South African case, the pressure on questions of genocide or on politically on just getting to the ceasefire sooner or later. It's going to happen this week, next week.
You think so?
Sooner or later, there's going to be a ceasefire of some kind or the other, in which the Israelis will simply say with the Americans that we're going to a new phase, which is not a total ceasefire, meaning of this big stuff, but then okay, let's do humanitarian, but we have the right to continue our operations against Hamas terrorists, etc. I mean that kind of thing. So not total stop, but stop on the major activities. That's going to come sooner or later.
What about withdrawing from Gaza?
No, I think that's what's going to take a long time. That's what they're going to say. If they don't do this, we do that. And if Hamas doesn't do this, we're not going to do this. And if they don't release the hostages, we're not going to do that. That's what's going to go on and on and on. And in the meantime, there are provocations towards here in Lebanon, the assassinations and the attacks and stuff. This has become much more serious over the past week or two.
Yeah.
That's not going to stop. They're going to continue assassination. They're going to continue attacking. Hezbollah has been extremely restrained so far, more or less. They keep hitting more important targets inside the Israeli territory, more and more. They hit a base a couple of days ago, military base. But so far, they're hitting mostly important and increasingly important military assets and bases and making things very difficult for the Israelis and preventing these, 200, 300,000 Israeli residents from returning to their own kind of towns and settlements and colonies. But this is not easy and this is difficult. And the last thing, even the Americans want, I think, is a regional war, which is already happening to an extent, from Yemen to Iraq to Lebanon. It's happening, but it's sort of in this medium level. But I mean to kind of go to the next level. So will the ICJ ruling? So just to recap, you've got this International Court of Justice ruling now on the South African case of genocide. You've got the International Court of Justice is supposed to also separately via the General Assembly meeting to discuss the implications of Israel's occupation. You have separately issues of the apartheid, that's ongoing, and you have the ICC case as well, the International Criminal Court that the Algerians and the Colombians have now sponsored and are trying to push and trying to get the ICC to kind of take more seriously. So you have all of these happening in these courts, in these institutional setups. The General Assembly has passed a bunch of resolutions. The Security Council is still being vetoed by the US, but it's quite isolated. So all of this movement is I think, significant, but will it change things on the ground? No, it's not going to change things immediately on the ground, but it will help, I think, the medium term, as Richard was saying, this larger South Africa style movement away from legitimizing the Israelis, moving towards boycotts. I think that'll increase, moving towards increased understanding that whatever moral ground that they might have had in the past in some countries, that's quickly kind of going away. The younger generation in particular, I think, is more exposed to this and might be much more understanding of this. And so if one wants to look at anything positive, it has to be along those lines, I think. Just one last thing from me here. I'm looking at the International Court of Justice website, and just for our purposes, you have a US judge who's the president, Russian who's a vice president, and then you have a Slovakian, a French, Moroccan, Somali, China, Uganda, India, Jamaica, Japan, Germany, Australia, Brazil, and our own Lebanese judge, who's of course Nawaf Salam, who's on the
We should have him on our show at some point.
Yeah, he's woke.
Seti, any last words on this? Do we
No,
wrap?
I mean, obviously, whatever happens in the ICJ, it's not going to stop the catastrophic harm being visited on Gaza and the West Bank and Lebanon now. It's just, it's not, we have to be aware of that, but it will add to, in the long run, it's going to add to what's already very much underway as a game-changing set of propositions in terms
Unless
of
the ICJ, of course, unless the ICJ says no, rules in favor of Israel.
Well, no, that's not going to happen.
I don't know. I can see them kicking it down I can see them hemming and hawing and doing something bureaucratic and legalistic and kicking it down the road. But I don't think they're going to say no. This is not a case. I can't imagine them doing that.
Okay. And so just a final point, which is, yes, there's those cases, and there's also questions of deterrence from Lebanon, from the Lebanese side, from Yemen, from Iraq. So there is a war going on that is also chipping away at the idea that Israel has this great military that's able to kind of project its power throughout the region. And it becomes clearer and clearer that without the US and their battleships and their warships and protection and arms that are coming in at a daily basis, the Israeli military is clearly much weaker than it was relatively 10 years ago and 20 years ago and 30 years ago. So there is this going on while these cases are taking place. And I think these are things we need to track in kind of forthcoming episodes.
Okay. Well, guys, thanks again very much.
Thank you very much.
Thank you.